Men's Forum, where we just discuss things that concern and impact men. I'm your host, Gary Costanza, and tonight's subject, what is the state of fathers' rights in New York? And it's my pleasure to introduce Sari Friedman, attorney at law, who is the general counsel to the Fathers' Rights Association of New York and Long Island. It's my pleasure again. Great to have you, Sari.
Thank you. Thank you very much.
You've been involved with fathers' rights for a number of years, fighting for fathers, for them to gain access to their children and legal rights. Why don't you tell us a little bit about your background and maybe what you're currently doing?
Sure. I've been practicing matrimonial law for, I guess, about 22 years now. As you pointed out, I'm general counsel to the Fathers' Rights Association. I write a number of articles for them on topics of matrimonial and family law, written from the point of view that a layperson should be able to understand it so that they can learn about their rights. We also hold regular meetings, usually in both Nassau and Suffolk, although right now the Suffolk meeting is, the library is under renovation, so at the moment we're just holding them in Nassau. It's normally in Nassau held the last Thursday of every month. For example, it's going to be held on September 26th, which is from our taping day, I guess 2 days from now. And people can come, they can ask questions, they can get information, and the idea is to make a father who's going through the process a better consumer and more educated about the process that they're about to go through. And of course I have my own practice where I practice matrimonial and family law. My office is in Garden City. The practice covers primarily Nassau and Suffolk, Queens, Brooklyn, and Manhattan. And we practice this on a day-to-day basis.
So you're making a difference in a lot of fathers' lives.
Well, we try to. We try to help people with regard to their problems and to put the pieces of their lives back together.
You know, I did go to your website, which we'll list at the ending credits. Also, the Fathers' Rights Association website there. And you will be able to view all these articles, which I have a list of. And yes, you're right, they are very simply written and understandable for the layperson.
Thank you.
Written in plain English. Let me just name a couple of these articles. The first one here, the term is the fatherist movement. I've never heard that term before, but I like it. Custody and visitation. Another article is grandparent visitation. What is a law guardian? I found this very interesting. In custody disputes, how does the court determine the best interest of the children? The primary parent. When the custodial parent wants to relocate, very important. Child visitation is a right, not a privilege. I like that. Equitable distribution. That could be a whole show right there. Child support. The new child support law. When is my child emancipated? And three that I really thought were very important. Protecting yourself from a spouse's order of protection under the new law. Probably a lot of you men out there can relate to this. How to improve your chances for a satisfactory settlement. That's very important, I believe.
Absolutely.
I read that. That was, we'll talk a little bit about that. And also, don't take her word for it.
Yeah, it's a catchy title.
It is. It sure was. A lot of times, we want to be the nice guy, and we take things for granted, or we don't expect the worst. Sometimes that's not good.
Actually, the basis for that article is experience in seeing how many instances. I'll give you examples. A gentleman will walk into my office and he'll say, I received a petition to go to family court saying I owe support arrears. My children are now under 21. But she told me for the last 3-4 years that as long as I sent our children this, that, and the other thing in college, that I don't have to pay it. Or what happened is my child came to live with me 3 years ago and I never went back to court. She says, don't worry about support. Or I fell on hard times and she said I don't have to go back to support. She would agree to take half the amount of support. And now she's suing me for all the arrears. And it's always the same question. Did you make this agreement with her in writing? Do you have something in writing that says that? No, I just took her word for it. And that's the problem. They go to court and they find that they have a problem in terms of defending themselves because they never got it in writing. Or another one, they are told, don't go to court, I've withdrawn my petition, be it for an order of protection, be it for support, be it for arrears, and then they don't show up that day and they find that their default was taken. Again, they took her word for it. What we're really simply trying to say is that don't ignore legal procedures and make sure that you get certain things in writing. Otherwise, the result could be detrimental.
As the article pointed out. Also, even if it's proven that the father's right, it's not retroactive. That money for 2-3 years is gone.
Absolutely.
Right?
If there's a reason that you feel you need to file and to reduce support, or you believe your child is emancipated before age 21, you've got an affirmative obligation to file and prove it. If you don't file, it's not retroactive. It's only from the date of filing.
Word to the wise. Very good. What do you mean by fatherless movement?
Okay. Well, what we were thinking of is, we had the feminist movement, and as part of the feminist movement, it was trying to create a general awareness in the public of equality for women in the workplace. And it seemed to me that I always found a parallel between that and fathers that I'm representing fighting for equality of recognition in the home as an equally important person in terms of child rearing. And that's why I said perhaps in terms of fathers achieving their goals, they ought to have a fatherist movement like women had a feminist movement. That was the essence of the article.
Very good. Do you think it's somewhat happening?
Well, a little bit, and I think what happens is law is the last thing to change. Society changes first, lifestyles change, and law changes last to reflect society. And as more and more women have been working, and as more and more women are equal wage earners in the household, or in many instances surpassing their husbands in terms of their earnings capacity and or the hours that they're working, fathers are taking on more and more responsibilities of a domestic nature. And as a result of that, you get different factual situations that are entering into the courthouse that really test our perceptions of right and wrong. I just did a trial in a case where I was representing a gentleman who was disabled and maintained that he was the primary caretaker of their son. The mother was a successful executive in a Long Island company and working full-time. And the question is who should have custody of the child? And it really called into question certain gender biases, if we will, or perceptions of right and wrong in society. And that's an example of what I mean.
Very good, very good. I think it is happening. From what I see, from the feedback I'm getting from different groups, and especially on the internet, I think that's a big boon to this new, I would call it the civil rights movement of the 21st century. I think fathers' rights. I think that's the last group that hasn't really made any inroads. So I think it will happen. It'll take some years, as you say. The groundswell happens first, and then the law is probably the last thing to happen.
It's funny. Over the years, what I've also found is sometimes when women are affected by the law or gender-neutral laws are passed that require doing things on a basis without looking at the facts and discretion, when men get equality. What I mean by that is back in 1989, when the legislature passed the Child Support Standards Act, which put in standards of what you have to order and support, I always said at that point, the people who are going to benefit from this are going to also be custodial fathers. Because prior to that time, if a father obtained custody, consider yourself lucky. If you then at the same time asked for support, the court's immediate reaction would be, well, why would you be asking for support unless you really don't want custody and it's all just a sham to try and not pay support yourself? And there was almost a shock when fathers at that point would ask for child support, and clearly there wasn't equality. If a father at that point would ask for child support, he would never obtain in similar circumstances what a wife or a mother would get. So that helped bring, in my viewpoint, equality to fathers in terms of what they could hope to receive in support. Now, what else has been happening, not really in New York, but around the country recently, and I'm sure you've heard of it, is this whole concept of homosexual marriages. And I raise that only because I've thought of the idea that if it's become legal in a couple of states, then obviously people who want to get married who are homosexuals are going to go to those states to do it. But once they go to other states, and we have full faith and credit, where one state gives full faith and credit to the laws of another, then it seems to me that we're going to start to have a time that couples of the same sex are going to get the divorce. Well, guess what? What is the court going to do when they're finally going to have to determine custodial issues and they can't look and see who's the mother and who's the father? Exactly. And they're really going to have to take a look at the roles that each parent assumes with the child. And one of the questions I have is, are they going to decide, you know what, maybe they both should share the time with the child. Maybe this concept like we have in New York, that a child has to always be in one home and a child can't sleep over the other parent's home on a weeknight, which barriers are starting to break down. Maybe they'll break down a lot faster because, you know, people, from my understanding, who obtain divorces in California, and I know this from speaking with people like yourselves who have gotten divorced in California, it seems to me that their understanding of normal is very different than it is here in New York. The gentlemen that I've spoken with in California have equal time with their children. They have time with their children during the week. And there isn't this concept that mom will be a custodial parent, you'll have alternate weekends from Friday to Sunday, and maybe you can have a dinner visit during the week. Now, granted, that is breaking down in New York, but nowhere like it is in California. So I've just oftentimes thought of that. Whenever we seem to have a situation that we can't look at the gender and it's something neutral, it helps create change.
We should look to that as an example. You're exactly right, because the gender issue is totally out of it.
Yes.
And then you'll be looking at it plainly as to who was the more involved parent or not, or
absolutely.
And maybe it'll be more obvious then that that's not fair.
Yeah. What's also interesting sometimes, I find, and we see this sometimes when I attend the fathers' rights meetings, and sometimes there are ladies in the group who are non-custodial parents. And what's interesting sometimes is when you hear their complaints, you start to question and learn if this at some level is also a gender issue or a custodial versus non-custodial parent issue, because many of their concerns about access, obtaining information concerning their child is the same complaints that men have. And sometimes you also find that when men are custodial parents, they're as critical as sometimes women who are custodial parents are towards the other spouse in terms of saying they're not exercising visitation properly, or they fed the child wrong, or they didn't dress the child right, or the child was dirty. So sometimes you find that these really are custodial versus non-custodial issues as opposed to just gender issues.
I could see that. You're right.
Yeah.
You're right. There's some other issues involved there.
Yeah.
What would you call joint custody?
Okay.
That's it's probably not a new term anymore.
No, no.
What would you consider that?
Joint custody really refers to legal decision-making in the state of New York. And right now, under the current state of the law in New York, courts are not going to order it unless the parties agree. I mean, if you find cases where absent parties' agreements, the court ordered joint custody, I would call them like needles in a haystack. And my experience, whenever I researched it, is once it got to the higher court, the appellate court, it was always reversed. And recently I had a case that made the Law Journal where a court awarded absent consent of the parties, joint legal custody, saying, I've seen in other behavior that the two of you have enough of an ability to get along and cooperate, and I think you ought to do it here for the benefit of the child. And the other side brought it up on appeal, and I was wondering what the appellate division was going to do with it, because it was a while since I had seen one of those cases. And they did what I had seen in the research with the other cases, at least in the second department. They struck it down.
Wow.
So really, joint custody is something you only have in New York by agreement. But let me answer your question, what does it mean? It means joint decisions of major issues. In other words, obviously a daily decision of what the child's going to wear that day, whether they're going to go to home from school with a particular friend to play. I mean, these are daily decisions of a day-to-day nature that's made clearly by the parent who the child's with that day. But if you're talking about major decisions, choice of medicine, choice of course of medicine, choice of extracurricular activities, choice of pediatrician, these are decisions that are made by the parent with the legal authority to do so, the custodial parent. In sole custody, a parent makes the decision and keeps the other informed. With joint custody, they're supposed to make the decisions together.
Okay.
Now, with regard to joint custody, most states, in fact, I would say I think it's about 44 states now, but not New York, have some kind of joint custody legislation on their books. New York does not. Personally, I don't agree with that. I know that the reason that New York doesn't is the philosophy is if people can get along well enough to make joint decisions, they could agree to have joint legal custody. But I don't always think that's so, and I'll explain to you why. I think most people are law-abiding citizens, and I think most people will do what they're told, okay, that the state expects from them. And I think the state is starting out sending the wrong message. If the state sent the message, we can order joint legal custody because we expect that the two of you are going to continue to communicate and get along for the benefit of that child, most people, I think, will do that. But when you're sitting there and you're counseling someone, like let's say I'm counseling a lady that I'm representing, and I would have to say, well, your husband wants joint legal custody, and she says to me, well, do I have to? Now remember my role as an attorney. I would have to say, well, no. What's going to happen if you go to trial is the court is going to award custody to one or the other of you, and if you believe in all likelihood it's going to be you, then no, you don't have to agree to joint legal custody. As opposed to sitting there and counseling her and saying, well, the court can award joint legal custody whether you agree or not, because it is the court's desire that the two of you will continue to consult on major issues. There's a difference. Now, obviously, it's not going to work in every case, but what you're missing is there are a number of people who, if told that's what's expected of you, will cooperate. And I find it hard to believe that a child is not better off with two cooperative parents.
Well, that's so important.
Yeah.
That's in the child's best interest.
Absolutely.
And that's the thrust of almost all of these family groups, fathers' rights groups, that is the best interest of the child.
I mean, there's always room for a court to change joint legal custody to sole custody if they're finding down the road that there's just no way it can work with these people. But I think what they're really missing is the large number of people who will abide by it.
So New York and a handful of other states are dinosaurs in this arena. One
can reasonably say that, yes.
Yep. California is probably at the forefront of fairness and real best interest of the child. I think that's called shared parenting.
It could be.
I believe that's what that would be called. And I believe that the major component of that is that an agreement as to physical custody between both parents. And if no agreement could be made as far as physical custody, then it would be 50-50. 50-50.
Well, I think that in certain states, my experience from speaking with people who got divorced in California is that's what they try to do, is to make it 50-50. In New York, essentially, we don't have that. The general rule of thumb is that a child has alternate weekends, one weekend in the custodial parent's house, one weekend in the other parent's house, and during the week, there's starting to be a breakdown. It had been, a father or the non-custodial parent, usually the father is the non-custodial parent, would have maybe an evening during the week from 4 to 8 or 5 to 7 or 5 to 7:30. I can, flex the hours a little bit. Then it went to 2 nights a week. And then there's been a breakdown in the sense that now in a number of instances, it could be a weekend will be Thursday night to return to school Monday morning, or in the second week Thursday night to Saturday morning, or there are a variety of those schedules, but it tends to be breaking down because fathers are more and more saying, I don't just want to be a visitor, and I can't have quality time with a child by going and traveling to the home, going and returning the child. What am I going to do in the interim? Feed them dinner at a diner? I mean, there's not quality time. Whereas if you have the child overnight and return to school the next day, you get to do normal activities, not Disneyland activities, homework, the washing, the reading of a story when you go to bed, and things that are more natural in nature.
It would seem that equal shared parenting would be fair for all parties concerned.
Yeah. I guess the opponents of that believe, well, it's not good for children, you're bouncing them around from house to house. But my point is, I've seen now in a number of instances in other states where it's working. So why does it work there and not in New York? I mean, why do they see the value of it? And sometimes when you raise that, people agree, or they can turn a deaf ear.
Well, as you say, it seems to be working in most other states. So I think it's inevitable it's going to happen here.
And it's also very good. We all agree that children need two parents, and when you turn a non-custodial parent into feeling that they're nothing other than a wallet, you're going to lose them, and they're going to run away and go in the other direction. And the person who's going to suffer from that is the child.
As far as move-away parents, is that allowed in this state? I would think that as part of any parenting bill, that there would be some sort of a state law that would forbid a parent from taking the child away at a certain distance.
Right.
Is there such a thing in other states?
Well, let's start with New York. I mean, that happens to be one area that, from my experience, the non-custodial parent is doing okay in. Once upon a time, we used to have this law that really kind of said you needed to have extraordinary circumstances to relocate. Then we had the Tropea case out of the Court of Appeals about, I guess about now 3 years ago. And it basically threw that law out and said we look at the best interest of the child, and there was a whole quandary, what does that mean, how's the court going to interpret it? But it really seems that the court has not, at the trial level, abandoned the concept of, if not extraordinary circumstances, then I would call it a very serious reason. They seem to acknowledge and respect the child's right to be locally with both parents, and a custodial parent who wants to relocate far enough away that it interferes with the other parent's right of regular access to the child has a burden to bear. And I've had many, many instances where such a request has therefore been denied. Now, what I find is interesting is a number of times litigants walk into my office after their divorce is done because they've got what we call post-judgment divorce problems, such as a parent who wants to relocate. And I look at their divorce agreement because, after all, about 90–95% of the cases in the court system really don't go to trial. They're ultimately settled, if not even settled, on the day of trial. And what I frequently find is a number of attorneys, in an effort to try and help the non-custodial parent, are putting in these radius clauses where the custodial parent agrees not to relocate more than. And I find invariably they're ending up hurting the non-custodial parent because people don't realize or think about how many miles they're talking about. First of all, they don't insert the word road miles, and then an argument develops as to whether that was meant road miles or as a crow flies.
Okay, right.
And we could both appreciate, if we're dealing with sky miles, how far 50 miles may be or 75 miles. And then somebody will come in my office and they sign this agreement saying the other parent, the custodial parent, can move 75 miles. And I said, hey, wait a minute. Did you think about that? Did you think about how far that is? And you're used to seeing your child every week and going to the schools and here, and they don't think about it, and they don't realize that sometimes they're agreeing to this radius clause, which really might very well be, if they had nothing, well in excess of anything the court might allow.
Wow.
So my point is that, you know, when people are going to come to these agreements, you really better think very hard about how far that is. I mean, if you're saying something like keep the child in the school district, or you're living in Nassau County and you have an agreement that says you can't leave the borders of Nassau County, or something reasonable, but it's just amazing to me how people just put these clauses in without thinking of the practical reality of it.
I never thought about that radius thing. You think of a number 50, that doesn't sound too bad, but when you actually do think about it, that can be very bad.
It is. It could be very, very far, and it might end up being farther than the court would ever dream of letting the parent go under the facts and circumstances of the case. So I think a number of instances, unless you're going to get a very tight radius clause, why agree to one at all?
Right, right. Or agree to, as you said, the county.
Exactly.
Don't leave the county or the school district.
Because it's funny, I was sitting in a case recently and somebody said 20 miles or something like that, and I looked at them and I said, do you know what that means? When you say 20 miles, and I even said it to the other parent who was going to be the custodial parent, neither one of them really even gave thought that they understood what the geographic boundaries are. So I changed the terminology. I said, what do you mean? How far would you go? And that's when we got to a real-life concept that they could relate to, well, the border. I mean, now all of a sudden you were talking about towns, and you were dealing with something that they could relate to.
Oh, very good.
And the other thing is when you say Suffolk County, do you know how far out Suffolk County is? Has anybody considered Montauk?
Look at that.
Look at that.
Look at that.
So the importance, I think, is to think in a practical sense of what are you talking about in terms of relocation, in terms of towns.
Okay. How about this? I believe you wrote an article, child visitation is a right, not a privilege. What's denial of visitation? What would that?
Well, I mean, first of all, you have to have visitation set. You can't take a parent to court complaining that your rights are being denied if you never went to court to set them. Okay? So once your rights are set, and I mean set in terms of days and times, not clauses like liberal visitation, because liberal visitation is not an enforceable clause. It's an agreement to agree. Because what's liberal visitation to one may not be liberal visitation to another. So I think what's important is to set dates and times. Now, sometimes people are getting along very well at the initial divorce, and they say a clause like liberal visitation because they're getting along, and they pick the child up here and there and whatever, and these two people really have not started to live separate lives, and they really don't anticipate what it's going to be all about. Well, now the divorce is over, they've moved on with their lives, or at least one person did, and all of a sudden they're no longer agreeable to that. So then you need to go back to court, and you're really going to need to set what liberal visitation is, because until it's set, it's not enforceable.
Okay.
And then you've got the dates and the times, and if somebody is denied visitation, it means that they're not getting the child when they're supposed to get the child. And my general rule of thumb is, while it may happen once because a child has another event or something, but if you're starting to get into things that are not healthy, like, Dad, I don't want to see you, I'll call you when I want to see you, and it may be a situation that you don't have a good, the dad doesn't have a good rapport with the mother, so the child is getting the front of it. My advice is to always go to court to get it fixed. It's like a cancer, and unless you get it fixed immediately, it's going to spread and it's going to get worse. It's a lot easier to go to a court and ask them to put your relationship back on track when it hasn't been that long a period of time than when you wait a tremendous period of time.
I see. Well, what can be done about it?
Well, the court will say, why is the child not going? They will look at the custodial parent and say that you have an obligation to force the visitation. What's the problem? Why doesn't the child want to go? The court may appoint what's called a law guardian. It's a lawyer that's appointed by the court to represent the child, to speak with the child, obviously if the child is old enough to be vocal, and to report back as to what the problem is, maybe make recommendations. If they feel there are psychological issues that are necessary, they could order an independent, neutral forensic psychologist to speak with everybody to get to the bottom of it. They could order therapeutic visitation if that's necessary. They can also just hold a hearing to find out what's going on, and they can simply hold somebody in contempt of court.
Okay.
They could go as far as changing custody. It really depends on the facts and circumstances, but they can do something, whatever the situation is, to hopefully get it back on track. But if you wait and you just sit back and you say, well, you know, I really didn't want to press the issue, I didn't want my child to go through this, I think if I wait, maybe they'll come back to me. I've seen so many instances where parents are sorry about that, and all it did is it led to a further deterioration and breakdown of the relationship.
Right, I see that. I see that. Now, I know some of those penalties are extreme, and are they ever enforced?
Ever? Yes. Frequently, perhaps no. In other words, I don't think that it's my experience that they're normally putting custodial parents in jail for denials of visitation. But one other effective tool that can be done is the concept of make-up visitation. I mean, if the custodial parent is going to find that they're going to just end up giving back the time, maybe that will act as a deterrent. But you really need to get to the bottom of the situation of why that is happening. And maybe if it keeps happening, then yeah, it is a basis for a change of custody. But there are other factors that one must consider. The children's feelings towards living with the other parent, you know, the relocation of the child. Is the other parent in the same school district? You're going to uproot the child. I mean, depending on the individual situation, there's a number of factors that need to be taken into consideration and weighed.
Wow. Very important, very important. Well, we seem to have run out of time.
Okay.
That surely went fast. Thank you, Sari.
Thank you.
Thank you for appearing on our show.
It was a pleasure.
You can contact Sari Friedman at 516-222-1030 or at www.sarilaw.com. You could look at the credits and find that out. Also, fathersrightsnys.com for the Father's Rights website. And also silentmajority.info, where you could find a shared parenting bill and sign a petition in support of that. Thank you and good night from the Men's Forum.
That went fast. What's it, a half-hour show? Wow, it flew.